Welcome to the Cherry Beckert Tax Beat, a conversation about tax that matters.
Welcome to this edition of the Cherry Beckert Tax Beat podcast. Today's topic is estate, gift, and trust update. It's never easy to discuss topics like this, not only involving your demise, but perhaps the demise of your loved ones around you. But it's very important that there's planning done, not only from the overall perspective of how you want your estate to be treated, but also, and more germane to this conversation, is the tax planning implications. So it's important to take time. This is a good time, end of the year, to talk about these type of things, to engage in planning about your estate. The extraordinary lifetime exclusion amount is set to expire at the end of 2025. This is bringing a lot of discussion in. The lifetime exclusion of 2026 may be half of the amount, just 1 year prior. So there's still some time to deal with this issue, but time will go by faster than we know it. All right, joining today's conversation, I have Mike Kirkman, partner and leader of our estate and gift trust services team, and Katie Sims, a manager with the same team. So Mike, how you doing today?
I'm doing good, Brooks. Glad to be here.
And whereabouts are you calling in from today?
I am calling in from Charlotte, North Carolina.
Charlotte, North Carolina. All right. And Katie, how are you doing?
I'm doing great. Hope everyone else is.
And where are you calling in from today?
I am calling from Charlotte, North Carolina as well.
Wow. I guess we're getting ganged up on by the Charlotte people. All righty. As always, joining me today, my partner in crime, Sarah McGregor. Miss McGregor, how's life treating you?
Life from the center of the tax universe right here in Greenville, South Carolina is all good.
Who do you like for the National Football Championship? Let's just get you on record right now.
It's very hard for me to pull against an SEC team.
Yeah.
So in that case, I would, but in this case, I'm going to go with Michigan.
All right. Well, I didn't say who were you pulling for. I was just saying, who do you think's going to win? Yeah, it would have been fun to, God, if we only had more teams this year, it'd been great to get Georgia and get Ohio State in there. But anyway, it is what it is, and feel sorry for our ACC brethren, Florida State. All right, just like the estate tax, we can't solve the labyrinth NCAA selection criteria either. All right. So, all right, let's move on to today's topic, the Tax Cuts and Jobs Act. Did I pronounce that right, Sarah?
Yes, you did.
All right. 2017 wrought significant changes to estate and gift tax planning. Under TCJA, the lifetime exclusion amount was raised to $10 million and can be ported over to a surviving spouse. And that's an interesting term of art verb right there. Now, nearly $26 million of asset value can be moved from a couple's estate to beneficiaries free of estate tax. And that's when we're starting to play with inflation adjustments and portability issues. All right, the next $1 asset value is hit with a 40% tax. Thoughtfully moving assets out of the estate and into ownership control takes planning, time, and attention to detail. Lots of lawyers and accountants involved. All right, so let's hit it. Katie, give us a quick overview of where we are in 2023 and 2024 when it comes to annual gift and estate exclusions.
For tax year 2023, the gift tax annual exclusion amount is going to be $17,000 per person. And in 2024, that amount will rise to $18,000. For the lifetime gifting and estate tax exclusion for taxpayers dying in 2023, that amount is $12,920,000 per person. And in 2024, that amount will rise to $13,610,000 per person, or roughly $27.22 million combined for married couples.
So there are 2 more years before the TCJA provisions expire. Why is it important to address planning now? We've got another 2 years to wait.
Yes, it's going to be very, very important to start planning now because at that strike of midnight on December 31st, 2025, the estate and gift tax lifetime exclusion is going to sunset from that $13.6 million to an estimated $7 million per person. So as you can tell, that is a drastic difference. For taxpayers who previously thought that they were nowhere near the lifetime exemption amount, it may be that they need to go back and analyze their lifetime estate and start planning for these changes now. It's going to be very important to start now versus later because many of these plans may include needing outside advice or assistance. For example, updating any corporate or operating agreements, drafting documents like wills or trusts. And as with any gifting, we need to think about valuations for adequate disclosure. So each of these action items are going to require some time to execute and a team of people to help. And with so many taxpayers that are going to be affected by the sunset, it's going to be important that we get started as soon as we can.
So I'm guessing you and Mike and the rest of the estate gift and trust team are already giving up your vacations for the next 2 years to help clients get ready for all of this?
Yes, gladly.
That's very cool.
We are quite busy.
Yeah, I imagine. So getting those appraisals, getting attorneys' time, getting y'all's time for planning is going to become less and less available as we get closer to that expected deadline. So, Mike, just shifting gears a little bit, we saw a number of interesting tax court cases this year dealing with estates. You want to talk about a couple of those? How about we start with the Schlapfer case? That's just for reference. It's a tax court memo case, 2023-65.
Yeah, and that's a great lead in to where Katie was going about valuations and adequate disclosure. And just for purposes of this case, and this is the first case that really focused in on adequate disclosure. And what adequate disclosure does, it's required in the regs, basically for gifts and filings of gift tax returns, you have to provide certain information to the service that gives them information to determine how the valuation of the gift was calculated and whether the gift, it can be a qualified appraisal, but it doesn't always have to be a qualified appraisal. The regs have there's 5 elements that deal with adequate disclosure, and the consequences of not having adequate disclosure on a gift tax return is the statute of limitations of 3 years doesn't run. So that just means the service can come back at any time and adjust that gift amount. And the IRS has always taken a very strict approach to adequate disclosure. And what this case did, and not to get deep into the facts, but it had some weird facts to it. But basically, the court held that the regs that determine what adequate disclosure is more of a guide, not shouldn't be a strict interpretation that you have to check each one of these elements off or you don't have adequate disclosure. So in this case, the taxpayer had information that was part of the gift tax return and actually information that was provided to the service that was not part of the gift tax return that the court held was adequate disclosure for gift tax purposes. So this is a very favorable case for the taxpayer.
So let's move to the estate of Cecil case. That's kind of interesting because of the location of the taxpayer.
Absolutely. For anyone listening to the podcast, if you've ever been to the Biltmore estate in Asheville, North Carolina, it's a beautiful place. And if you've never been there, I highly recommend it. It's fascinating. The Vanderbilt family still owns the property, and it's been in this family for many, many years. And this case is really centered around a valuation issue. So if you can envision the estate in Biltmore is the largest residence in the U.S. So there were gifts of shares of the Biltmore family members, and there was a valuation determined of what the interest in those shares were to the family members. And the IRS came in and said, no, that we don't agree with that valuation. And the differential on the valuation was the IRS was taking the position that the valuation should be based on the liquidation value of the assets, meaning all the property. And it was determined that that was somewhere in the range of 150 to 160 million. But the valuation that was done by the taxpayer on the gifts to the family member was based on the cash flow of the operations. So when you go to the Biltmore house to take a tour, you pay a fee, and they have some shops there, and they have food, and they have a winery and things, and that's how the taxpayer based its valuation on is actual cash flow of the operations. And cutting to the chase, the IRS agreed. I mean, the tax court agreed with the Biltmore family because there was such restrictions placed on the ability to even sell that property. So even if a family member wanted to sell the property, and the valuation differential was well over $100 million difference, but the valuation on the liquidation value was so prohibited that none of the family members would have the ability to sell the property. So the tax court agreed with the taxpayer. And I emphasize this case for one other reason, is the IRS and the taxpayers valuation experts both agreed that if you were basing the valuation on the cash flow of the operations, that the valuation should be based on a tax affecting, meaning net of the income tax on the actual income of the property. Even though the IRS did not value it that way for gift tax purposes, they did agree, which is very important for valuation purposes going forward. But very interesting case.
Yeah. So if the operations turned out $10 million a year and the tax effect on that was 40%, then the valuation is based on the net $6 million a year, not on the gross 10. That's really very helpful. So a nice win for the taxpayers there.
Absolutely.
Yeah. So Katie, while we're talking about trusts, I wanted to get back to that. So what sort of planning should folks think about with trusts, and is there something they can do? I mean, we're close to the end of this year, but I think there's still some ability to make some changes after year end. Isn't that correct?
Yes, that is correct. As with any tax year, we want to take a look at any potential to make distributions to beneficiaries, either by the year end or within the first 65 days of the next taxable year. Trusts do reach the highest tax bracket at only $14,450 of taxable income for 2023. So we definitely do encourage trustees to make any distributions to beneficiaries in lower tax brackets if applicable. Also, for trusts that grant substitution powers, we can take a look at assets of equivalent values with low appreciation to swap out with assets of high appreciation. So this will help move assets around, maybe with some depressed values back into the estate. That will help those assets with depressed values receive the benefit of the step up in basis when the taxpayer dies. Additionally, for any rapidly appreciating assets, it may be appropriate to swap those assets with assets that have leveled off, or maybe assets that are declining in value. And this is going to remove a highly appreciated asset from the estate. And the potential benefit of that would be removing that asset from the estate at a high value that maybe would trigger a filing requirement under the potential sunset. And then finally, as with any tax year, just sitting down to review any existing trust agreements. This is going to help ensure that all of your trusts are still in line with what you originally set out to achieve. Because as we all know, life changes really fast. So making sure your affairs are in order annually, that's a great estate planning practice for yourself and your family.
So children grow up, there are new grandchildren, there might be education needs, or people grow out of education needs. Spouses change. Lots of factors can affect a family. And so what you thought was a good trust provision, tax laws change, economies change. So what might have been good 3 to 5 years ago might not be as suitable now for a trust.
Yes, definitely.
My parents may quibble with you under the assumption that kids grow up, however, Sarah. So, Mike, let's go to one of our favorite topics, your and my favorite topic, slats. So, I mean, we could spend a whole podcast talking about slats, but let's do the quick overview. So, define what slats are, what they do, how, and what they accomplish.
Absolutely. It's in the tax world, we use a lot of acronyms. SLAT is basically Spousal Lifetime Access Trust. So as Katie mentioned earlier, the exemption's at an all-time high, 13 million. And when the exemption, when I first started practicing, it was $600,000. And when you're going to a wealthy family saying, hey, let's move $600,000 out of your estate, that's one mechanism. And that's one statement. And that's not as breathtaking as saying, hey, we need to move 13 million out of your estate and away from you. And what does that do? Well, it accomplishes a lot of potential estate tax savings, but the person or the family that earned that money wants to utilize that income stream and those assets to enjoy their life and their hard work. So a SLAT was identified. It's nothing that new. It's a trust that's created by a donor to a spouse and future generations. And moving that large amount of wealth out of someone's estate, but still having the spouse attached as a beneficiary of that trust, has this the sense of moving it from your right pocket to your left pocket. So the person who's making the gift, the one spouse, to the trust for the benefit of the spouse and future generations, indirectly continues to keep the income stream via the surviving or via the spouse. You've got to be real careful when you're creating slats for both spouses. So one spouse creates one for the other, and the other one creates one for the first spouse that created the slat, because of this reciprocal trust theory. And basically, if those are identical slats, the service in a case called Grace collapsed both of them because it said the taxpayer, husband and wife, were economically in the exact same situation. And there's a lot of planning that goes around that, but slats are, in a sense, a way of moving a significant amount of wealth away, but indirectly keeping access to that income stream.
It's like the best estate planning technique ever. And sooner or later, somebody's going to catch up with it and try to put some more severe restrictions on it, I think. But while in this period of time, with the high exemption, I can't emphasize, I'm so enthusiastic about using slats. They just get so much done in such an efficient manner. All right, Mike, let's just jump on, and I'm going to butcher this name, about this other case, the estate of Hoinscheid.
That's right.
Correct my pronunciation.
Yeah, that's correct. Hoinscheid, and it's a tax court memo 2023-34, and basically this is your classic family that wanted to make gifts of closely held stock to a charitable organization, a DAF. And basically, before the gift was made, there were already plans in place to sell the company. So the closeness to the gift and to the agreement to sell the company was viewed as too close together, and the assignment of income rule was ruled by the tax court to apply here. So the gifting of the shares, which is very common when closely held businesses are contemplating to be sold, part of the planning is maybe you give some of the shares away to get a charitable deduction, and marry that up with the capital gain or the income that's generated from the sale. But if it's not done properly, it can all be collapsed. And so in this case, it was collapsed, and there were no charitable deductions allowed, and all the income that resulted from the sale of the shares in the charity that would normally have been not taxable were passed back to the taxpayer, and the taxpayer had to pay 100% the income tax on the full sale price. So due diligence on the front end, if you're contemplating the sale of your company and also simultaneously making a gift, you need to do a lot of planning to make sure all the I's are dotted and the T's are crossed in the correct way.
Yeah, this is a clear example of don't do it this way if you want it to be a successful transaction.
Well, I
That's
think
correct.
even better statement on it is do it early. You know, the closer
right.
you get, closer you get to doing those things to the date of sale, the more problematic they get. So
that's right. Well, Mike, Katie, we've talked about planning for really large estates and how important that is, and using up that $27 million lifetime exclusion for a married couple. But there's a lot of folks whose estates are not that large. What sort of planning or ideas could we should those with a bit more modest estates be thinking about?
While we do tend to focus more on federal thresholds, as these tend to apply to everyone, there are 17 states and Washington, D.C. that have either or both estate or inheritance taxes with much lower thresholds. So staying up to date on your resident state estate tax laws will help you avoid any major surprises.
That's correct. And also, as Katie mentioned earlier in the podcast, even though a taxable family or a taxable estate situation, it doesn't exist because of the $26 million exclusion for a married couple, that number is going to change unless Congress acts, which is probably very unlikely. And the number is going to drop dramatically. So utilizing as much as you can through planning today will prevent someone going from I'm not going to have a taxable estate to, oh my gosh, I very well may have a taxable estate. And particularly with the asset growth over someone's lifetime, even if they're under the reduced potentially $7 million exclusion, $14 million over a span of a period of a lot of years, that number can exceed and then be in a taxable estate situation. So it's very important to plan, even though you're not at the threshold today, but just to sit down and look at where it potentially could end up post 2026.
all right. One last question, Mike. What do you anticipate your clients will need help with in the next few years?
Yeah, the big elephant in the room is, as we've mentioned several times, is the exclusion sunsetting in 2026. There's a lot of planning. And as Katie mentioned, you really need to start early, because it's not just, hey, just sign this document. There's a lot of questions and a lot of planning that goes around structuring these planning strategies. Valuations do not occur overnight. And if we wait till the middle of 2025, it's going to be very difficult to even find attorneys that can draft documents and valuation folks that are not already extremely busy. And charitable planning is the exact same thing. So I think structuring large gifts, charitable planning, and the need to look at the sunsetting that's going to occur in 2026.
All right. Let's move on to final comments. Katie, you have any final words of wisdom you'd like to share?
Sure. I would just advise clients to take advantage of anything they can. The annual gift tax exclusions, charitable giving, direct tuition or medical expense payments. Those are all ways to help move assets, move cash out of your estate that that don't require a lot of planning or technical advice. So that's always one quick little tidbit that many people forget about.
You're so right. And it can add up very quickly
Yes.
over time if you just that very simple blocking and tackling. All right, Mike, what you got for us?
Yeah, I would just add on to that with one of the items that you can plan around that moves a significant amount of money out of a person's estate is, say, grandparents funding 529 plans for grandkids. It's not considered a taxable transfer, and you can maximize that by taking the exclusion, which is 17, multiply it times 5, and you can get a larger chunk at one time. So you can imagine if you've got a family that's got 5, 6, 7 grandkids, that can move a significant amount of money out of someone's estate. And as Katie mentioned, a lot of these techniques are very straightforward and simple. So it's not always the complicated things that accomplish your goals.
And Sarah.
I would say we talk about needing to get the planning underway for access to attorneys and appraisers and tax professionals. I would also say the individuals need time to think about gifting away part of their estates and letting go some of that control. So that also needs to be factored in to this time that we have between now and when the lifetime exclusion will decrease, is that it does take individuals time to work through the plan to actually move some of their lifetime assets.
Okay, and for me, I'm gonna go back and revisit slats just because I'm such a fan. But I'm just gonna put a slightly different spin. If you're a person and you are concerned about a taxable estate, or you're concerned about asset protection, losing money from whatever, medical catastrophes, lawsuits, or whatever, and you want to do things, and I think as Mike went on about this, you still want the access to that money to live on, and you still want an indirect means to get to principal if you need it. These slats are a beautiful planning technique. They do take a lot of effort and work to put them into place, but right now it seems to solve so many issues for people that fit into that fact pattern. All right, so that's a wrap on today's discussion about tax planning for estates, gifts, and trusts. Thank you for listening in. A quick disclaimer that we are not providing tax advice on this podcast. Please consult with your tax advisor, hopefully at Cherry Beckert, with your specific tax issues or to discuss information from today's podcast. Check out the firm's website at cbh.com for the latest guidance and materials on this and other tax and business topics. This concludes today's podcast. Please like, share, and subscribe. Thank you, Katie. Thank you, Mike. Thank you, our listeners, for spending your time with us. We truly appreciate it. Have great holidays. Let's call it a day and go forth in peace.